Yes, Your Honor, as the court's aware, he's had some health issues recently, but we have been dealing with that and talking to the prosecutor. We have a trial, I think, scheduled at the end of the year in December, but we're still working out some of the other issues. But those health issues, kind of delayed those talks a little bit. So if we could get another pre-trial in like 3 weeks or so, I think we'd have a better update for the court on, some of those outstanding issues that we're trying to get resolved before the trial.
Okay, Ms. McClure, is there anything we need to address from the people's side at this point?
No, Your Honor, I would agree.
Okay. Do August, several weeks are booked up pretty solid. Looks like August 27th would be the first opportunity.
We'll take that, Your Honor.
Okay, so August 27th at 8:15, and Mr. Fry, would you do a stipulation in order for that adjournment?
Yes, I can prepare that. Ms. McClure, could I sign your name with your permission to that stipulation order?
You can.
Thank you.
Okay, anything else we need to address today?
No, Your Honor.
Nothing on behalf of the people. Thank you.
All right, Mr. Goebel, you're all set for today. Then your next date will be August 27th at 8:15.
Okay, thank you.
You can let the officer know that you're done with court. You had one other person.
Edward Edwards, I think, is the last one I have with you. Okay.
And Mr. Dagger Margosian, I think we lost Mr. Coleman. Okay, Mr. Raines, are you ready to proceed with Mr. Spenceley's case?
Yes, good morning, Your Honor. We are. Mr. Spenceley is present with me in my office.
Okay, give me 1 second. Okay, this is file 25-52331-PP, Nicole Reisinger versus David Dale Spenceley Jr. We are here today for a hearing on an order to show cause related to an alleged violation of personal protection order. We are proceeding today video conference Mr. Raines, would you like to place your appearance on the record?
Yes, good morning, Your Honor. Matt Raines appearing on behalf of and with the defendant/respondent, David Spensley.
And sir, you are David Dale Spensley Jr.?
Yes.
Mr. Spensley, you're before the court today on an order to show cause that alleges that you violated a personal protection order by sending a text message to the petitioner on May 25th, 2025. The maximum possible penalty for a contempt of court for violating a personal protection order is up to 93 days in jail and or a $500 fine. You do have the ability to be represented by an attorney. Obviously, you're represented by Mr. Raines. At this point, Mr. Raines, do you know how Mr. Spensley would like to proceed with respect to this alleged violation?
Your Honor, we would enter a plea of not guilty at this time and request that a hearing be scheduled.
All right. It looks just to me, based on the allegation, that an hour should probably be sufficient to.
I would agree, Your Honor. Yeah.
Okay. Ms. Clark, we have a 1 hour hearing date for a PPO violation.
Thursday, August 7th at 2:30.
Your Honor, I have a 2-hour review hearing scheduled before Judge Anzalone that scheduled at 1:30. Would it be possible to set this matter at 3:30?
That would be fine.
All right. Thank you, Your Honor.
Okay, so that was August 7th, and that will be at 3:30. Okay, court will issue a scheduling order and get that mailed out to you.
Very good. Thank you, Judge.
Thank you. I'll Jim for Mr. Mendoza, so please.
What's going to Joseph first? What's on the search, but we need, and we also need Ava Mendoza, please, for the judge. Thank you. Bye.
Okay, we can call Daniels. This is file 24-21844-FH, People versus Robert Glenn Daniels. We are here today for a hearing on an order to show cause for, hearing on a request and summons for probation violation. Courtroom is open to public and there is a Zoom session running. The record should reflect that Mr. Daniels was ordered to appear in court this morning with respect to the probation violation at 8:15 a.m. It is now 9:09 a.m. and Mr. Daniels has not appeared. I am going to issue a bench warrant for his arrest, and I will set bond on that bench warrant in the amount of $25,000 cash or surety.
Thank you, Judge.
Thank you, Ms. Holly. Ms. Underwood, we have not had Mr. Hall logged in from MBOC.
This is a competency update, Your Honor. I believe we can proceed.
Okay. All right, so this is file 24-21859-FH, People versus Michael Hall. We are here today for a review hearing. Mr. Hall had previously been referred to the Forensic Center for competency. And first, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, Map the People.
Rhonda Underwood on behalf of Mr. Hall this morning, Your Honor. Your Honor, the most recent update from the Forensic Center provided to us on, I believe it's dated 6/25, Your Honor, is that Mr. Hall remains incompetent but restorable, and they are making every effort to comply with your order of restoration. But I do believe we need to set this out perhaps another 90 days to allow progress on that, Your Honor.
Okay, Ms. McClure, anything else we need to address on the people's side?
No, I would agree, Your Honor.
Okay, let's set this then for October 15th at 8:15 a.m.
I will be happy to do the stipulation and adjournment with Ms. McClure's permission.
No objection.
Okay, thank you. Okay, you, Christina Sanford. This is file 24-21832-FH, People versus Christina Marie Sanford. We are here today for a hearing on a probation violation. We are proceeding today by video conference. The courtroom is also open to the public. The record should reflect that Ms. Sanford was ordered to appear in court this morning regarding the probation violation, and she was ordered to appear at 8:15 this morning. It is now 9:13 a.m. Ms. Sanford has failed to appear. I am going to issue a bench warrant for her arrest and set bond on that bench warrant in the amount of $25,000 cash for surety.
Your Honor, I believe that might complete my docket with you this morning?
I believe it does, yes.
Thank you.
All right, and sir, you are Edward Edwards?
Yes, sir.
This is file 25-22177-FH and 25-22178-FH. People versus Edward Earl Edwards. We are here today for a pretrial in both of those cases. There is also a pending contempt in the 22177 case. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Good morning, Your Honor. Brian Fry, appearing for Edward Edwards.
And Mr. Fry, where do we stand with Mr. Edwards' case?
Yes, Your Honor. We have a trial scheduled in October in this case, which we're inching towards. We'd be asking maybe for another pretrial in August to see where we stand then. Additionally, the jail apparently has a jail services coordinator now, Tamara Fitzgerald. My client has been involved in the engagement group there for substance use. And my understanding is they think it would be beneficial for him to attend a inpatient rehabilitation program for substance use. And she had apparently already found a bed, but I said, he can't be released without a court order, so that doesn't do us much good unless the court orders that could happen. So we would ask that the court amend the bond, I guess, or the order that would allow release into a long-term inpatient rehabilitation. That's 90 days or whatever, obviously not like a 7 or 14 day. But if the court would amend that, and obviously when he completes that, he would go back to jail unless it's amended again. But he is seeking that treatment. He's made a lot of progress there in his groups in jail, but my understanding is that he would benefit from that additional intensive treatment that a specialized program could offer. So we would ask that the court consider allowing that. Thank you.
All right, Mr. McCready.
Yes, as long as it's an inpatient facility and he is released directly to that facility and then returns to jail upon completion, we would have no objection.
Mr. Fry, is the pretrial just related to plea discussions, or are there other issues that the court might need to address?
Potential, it would be our progress on a resolution, Your Honor.
Okay. All right, let's go. How about September 3rd at 8:15 a.m. for that?
That works for me.
And would you be willing to do a stipulation order for that? Sure.
Yes, I can prepare that. Mr. McCready, could I sign your name with permission?
That's fine.
Thank you.
Mr. Oh, I'm sorry, I think we're all set with that one then. Mr. Edwards, you can I'm sorry, I didn't address the bond issue. Yeah, that is, I think, a reasonable modification of bond under the circumstances and having looked at the charges. So I will modify bond to allow Mr. Edwards to be released to a residential inpatient treatment facility with the condition that upon completion, he return to the jail unless there are further orders from the court addressing that issue.
Thank you, Your Honor.
Okay, so now, Mr. Edwards, you can let the officer with you know that you're done with court.
Thank you, Your Honor.
And Mr. Murphy, will you need a breakout session with Mr. Mendoza?
I don't, Your Honor. This is just an arraignment.
Okay. Okay, let me do Mr. Mendoza, and then I'll come back to Mr. Forbes Lovett because I do have that form now. Okay, so this is file 25-22323-FH, 25-22324-FH, and 25-22325-FH. People versus Abel Mendoza. We are here today for arraignment in all three of those files. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Phoebe McClure, map the people.
Matthew Murphy appearing behalf of Mr. Mendoza.
And sir, you are Abel Mendoza, correct?
Yes, Your Honor.
Mr. Murphy, does Mr. Mendoza wish to have the information read today?
No, Your Honor. We acknowledge receipt of the information in the three files, and the witness list and the discovery request by the prosecution in all three files. We'd ask the court to enter and continue a not guilty plea for Mr. Mendoza and set the cases for pretrial as soon as the court finds and is scheduled to do so.
Right, I will enter a not guilty plea for Mr. Mendoza in all three files, and we can set this for a pretrial conference on August 27th.
Thank you, Your Honor. Your Honor, could I briefly address bond, Mr. Mendoza?
Go ahead.
Your Honor, Mr. Mendoza again has three files. I believe his bond is 2,500 and 250,578, 2,500 and 250,500. That being failure to comply with sex offender and then dangerous weapon, possession of a dangerous weapon. And then in file 251133, unlawful driving away of motor vehicle, it's 10,000. I'd ask court to consider reducing the bond in the motor vehicle file in 251133 to 2,500, similar to the other two files, making his total bond down from 15,000 right now to what would that be, 7,500. I don't believe that Mr. Mendoza is a flight risk, though, Your Honor. I don't believe that further incarceration is necessary. I don't believe he ultimately can post the bond right now. So obviously, as I always ask the court to consider maybe a PR bond, but if the court's not willing to consider that, reduction in bond like that, I think might be appropriate. Maybe Mr. Mendoza could post that bond.
Ms. McClure, do the people have any position on that?
Just that bond was reviewed in district court following Mr. Mendoza's failure to appear. So I'd ask the court to consider that in considering any bond reduction, and we would object to any significant reduction.
All right, so Mr. Mendoza has apparently a failure to appear in the other two files, in 324 and 323 file. He also, in these files, one charge is for possession of a dangerous weapon. One charge is failure to comply with reporting duties under SORA. The most recent charge, an unlawful driving away. Each of the three, apparently three separate instances, because they have three separate offense dates. I think that under the circumstances, I believe bond is appropriately set for Mr. Mendoza. I think there is some concern about knowing where he is based on the failure to comply with reporting duties charge. And so I think, and also the failure to appear. And so I think that bond is appropriately set, and that will deny the request to modify bond.
Thank you for taking the time to consider it, Your Honor. Mr. Mendoza, I'm going to Zoom later this afternoon with you, okay?
All right. Thank you, Your Honor.
Thank you, Mr. Mendoza. You can let the officer with you know that you're done with court.
Thank you.
We're back. Just a little bit. Okay, we're back on the record in file 25-22219-FH People versus Jacob Forbes Lovett. I do now have that advice of rights form, and there is amended information and plea agreement in file.
I'm done.
And I apologize, Ms. Aycock, if you had already stated the terms of the agreement for the record. I have forgotten. Have you done that already?
I have not, Your Honor.
Okay, do you want to go ahead and do that now then?
Certainly. The plea agreement as executed by the defendant is he will plead guilty to count 4, which is reckless driving, along with added count 5, fleeing and eluding 4th degree under the Motor Vehicle Code. Nolle pros, the remaining charges, and that is the plea as I understand it.
And I can further elaborate if the court doesn't mind.
Go ahead.
Just to place on the record that this defendant has presented to me a certificate of completion for a driver improvement course, which I considered in order for him to obtain this plea. In addition, by statute, the Secretary of State will suspend his license for 1 year. That's, again, statutory. I just noted it on the plea form, so he was aware of that. Otherwise, nothing to add.
Is that all accurate, Ms. Aycock?
That is correct, Your Honor. Thank you.
Okay. Mr. Forbes Lovett, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
Okay, and you are Jacob Valentino Forbes Lovett?
Yes.
And Mr. Forbes Lovett, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 4 reckless driving?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a fine of $500?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 5, 4th degree fleeing and eluding a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $500 fine?
Yes, Your Honor.
Do you also understand that requires the Secretary of State to suspend your driver's license for 1 year.
Yes, Your Honor.
Are you satisfied with Ms. Aycock and the advice that she's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct, Your Honor.
Ms. Aycock?
That is correct, Your Honor.
Is that also your understanding, Mr. Forbes Lovett?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Forbes Lovett, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 26, 2025, in Franklin Township, Lenawee County, Michigan, that you did commit the offense of reckless driving?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about January 26, 2025, in Franklin Township, Lenawee County, that you did commit the offense of fourth degree fleeing a police officer?
Guilty, Your Honor.
Has anybody made any threats or promises to you to get you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Forbes Lovett to plead guilty today?
None, Your Honor.
No, Your Honor.
Mr. Forbes Lovett, has your attorney promised you any particular sentence or estimated what your sentence would be?
Not exactly. No, Your Honor.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Aycock, do you want to establish the factual basis?
Yes, I can, Your Honor.
Okay, go ahead.
Thank you. I'm going to bring your attention back to January 26, 2025. Do you recall that date?
Yes.
On that date, were you operating a motor vehicle?
Yes, it was.
At that time, were you operating it in Franklin Township?
Yes.
Can you speak a little louder?
Yes.
And that's in Lenawee County, correct?
Yes, ma'am.
A police officer, as you were operating that vehicle, you were on a public roadway?
Yes.
And a police officer activated his emergency lights and/or siren behind you, correct?
Yes.
And at the time those lights were activated, you were driving, correct?
Yes.
Did you in fact pull over when the officer was behind you with his lights activated? You failed to obey his direction by increasing your speed and continuing driving. Is that correct?
Yes.
While you were
I'm
doing
sorry, I need Mr. Forbes Lovett to speak louder. We're not catching his voice on the microphone.
Sorry.
when the emergency lights were activated, you did not pull over, correct?
Correct.
And in fact, you continued driving your vehicle?
Yes.
And as you continue driving, did you increase the speed?
Yes.
Okay.
Yes.
And did you exceed the speed limit?
Yes.
Did you drive on the wrong side of the road at one point in time as well?
Yes.
And at that point in time, were you in disregard of the public safety?
Yes.
I have nothing further, Your Honor.
Ms. McClure, are the people satisfied?
Just for purposes of the plea, would you agree that this incident ended with a collision and or an accident?
Yes.
Can speak up.
Yes.
Okay, people are satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Akon?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Forbes Lovett has had full knowledge of his rights. So the court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation, and we can set sentencing for August 29th at 8:15 a.m.
Your Honor, would that be by Zoom as well?
We can do that by Zoom if Mr. Forbes Lovett will waive his right to be sentenced in person. So Mr. Forbes Lovett, you have a right to be sentenced to be in person for the sentencing hearing. We can do it by Zoom, but you would need to waive your right to be here in person.
That is okay, Your Honor.
You are waiving your right to be
I'm
in
waiving.
person?
Yeah, my right.
Okay, so we can do that by Zoom.
Thank you, Your Honor.
Probation department, Mr. Forbes Lovett, will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
Okay, and I'm going to put you in a breakout session with Ms. Holly from the probation department so she can collect your contact information and give you some information about what you're going to need to do next for that.
Thank you, Your Honor.
Okay, Mr. Dunning, we're just waiting for Mr. Malero. He's probably next door handling cases with Judge Anselm. So as soon as he's here, we'll get to your case.
Judge, if we don't have any attorneys or defendants at the moment, I'm going to step out for maybe 4 minutes.
Okay, yeah, that's fine. I think all of the cases I have left are Mr. Malero and the Coleman with Mr. Dagenberg. He's not here yet. So yeah, that's
Okay, thank you.
Good morning, Mr. Malaro. Mr. Dunning is here in the courtroom. Do you need to speak to him?
I do not, Your Honor.
Okay. Okay, this is file 20. Oh, let me make sure. Ms. McClure, are you there? All right, Ms. McClure said she had to step out for a moment. As soon as she's back, we'll get started.
Okay.
Okay. That's what I'm saying. I don't know how many he's setting up. He said, who we setting up, how many he's setting up, those kind of.
There's Phoebe.
Hi, this is Judge Olsaver's office. We need Kareem Jamal Muhammad Henry and we also yep, bye.
Okay, so this is file 25-22172-FH People versus Dwayne John Dunning. We are here today for a pretrial conference. In this case, we're proceeding today partially in person and partially by video conference. First, may I have the attorneys place their appearances on the record.
Sorry, I didn't realize I was muted. Phoebe McClure, of the people.
Salvatore Malero on behalf of Dwayne Dunning.
All right, Mr. Malero, where are we with Mr. Dunning's case today?
Your Honor, I would ask for a brief adjournment. The basis for that is some information recently came to my attention that I conveyed to Mrs. McClure. She has not been able to verify it. I'll try to do that for her, and then I believe there will be a resolution.
Yeah, between maybe Mr. Malaro's investigator and the City of Adrian police officer in this case, I think we'll be able to get to the bottom of it and figure out exactly how to move forward with this case.
All right, I'll adjourn it to August 27th at 8:15 a.m. Mr. Malero, would you do the stipulation in order for that adjournment?
Yes, I will, Your Honor.
Okay, so Mr. Dunning, your next date is August 27th at 8:15 a.m. So you're all set, thank you. All right, and Mr. Malero, we have called the jail for your other cases. Mr. Dagger Margosian, Mr. Coleman at some point left the meeting and he's not returned.
Did he ever come back?
No, there's someone just popped up in the Zoom with Jen. I don't know if that's related. All right, good morning. For the person that just logged into the Zoom session, can you tell me your name?
Jana Penrod, psychologist.
Okay, and what case are you here for?
Plesha.
Do you happen to have the case number for that? I don't have that one on my docket.
Oh, I got a call yesterday from an attorney saying 10 o'clock today with you. Kyle Plesha.
Do you happen to know his case number?
I don't get that information.
Do you know can you spell that last name for me?
Plesha.
Okay, give me a moment. Let me try to look him up.
I appreciate it.
And I'm sorry, what was the first name?
Kyle. Maybe I have a number here.
What is it that you have?
255317. I may have the wrong client. It's the way my week's going. Is it Gregory? Aiden Gregory?
Okay, it looks like that is Judge Sala's case.
At 10?
I don't know what time.
Okay. I will pop over there. Do you have an Aiden Gregory coming up, I'm guessing?
No, I don't have anyone named Aiden Gregory on my docket today.
Okay. Sorry for the confusion. I will change courts.
Okay, no problem.
Thank you.
Yep. Okay, so yeah, Mr. Coleman dropped out sometime, I think, shortly after we were on the record with him, and we faxed that document over. And I have not seen him since. Do you have any way to contact him? Or?
Not really, but I believe he's at a Spera facility, and that's really all that I have.
Okay. Thought I had someone in a Zoom booth, and now I don't.
Judge, he is at Spera, which is part of Dawn Farms. I'll give him a call real quick and see if he can connect.
Okay, thank you.
Yeah. Okay.
Judge referenced Joshua Coleman. I did reach Spera, and they indicated that he actually left yesterday against staff advice.
Okay. Mr. Dagger Margosian stepped out, so as soon as he comes back.
Very good.
Hi. I'm trying to get a hold of jurors that I need. We have 3 that are there that we needed to put into a sleeper. Correct. Okay. Thank you. We have a trial starting next week, so we're trying to get through our docket. We have Kareem Henry, Matthew May, and Dustin Smith. Perfect. Thank you so much. Bye.
Okay, we can go back and record for Olsaver. This is file 25-22283-FH and 25-22320-FH. People versus Joshua Glenn Pullman. We were on the record previously and were trying to arrange to fax a advice of rights form to Mr. Pullman at his inpatient facility. After we were on the record, at some point he dropped out of the meeting, and Mr. Coast indicated you were going to contact the facility, and Mr. Coast, you told me off the record that you want to repeat now that Mr. Dagger-Rogosian is present.
Yes, Judge, I did contact Spira staff. They indicated that he actually left their facility yesterday against staff advice. After leaving, he failed to get a hold of me, reference starting up drug screens again. And Judge, it should be noted, prior to him going into treatment, he did test positive for marijuana, ecstasy, and also meth.
Okay, Mr. Dagger-Rogosian, obviously you're just learning about that. I don't know if there's anything you want to comment on at this point.
I don't think I have any comments. I guess I will, on my end, try to. I mean, I know Mr. Post spoke with workers at Spira. I don't think I have anything to add right now. Okay. Yeah. Yeah, that's fine.
All right, Mr. Coase, you have contact information for Mr. Coleman? Or was it just at the facility?
Judge, it was just at the facility. I just have his home address. I do not have a telephone number for him.
All right. What I'm going to do then is based on that information, ask Mr. Coase to prepare a motion affidavit for bench warrant based on what appears to be a bond violation. I would intend to sign that, and if for some reason we hear from Mr. Coleman and there's an explanation, we can arrange a hearing on the record. But at the moment, it appears that the bench warrant is the more appropriate thing to do. All right, so that will be all for Mr. Coleman's case today.
Thank you, Judge.
Okay, for the gentleman that just stepped into the Zoom room at the jail, can you tell me your name?
Me?
Yeah, go ahead.
Matthew May.
Okay.
Justin Smith.
Okay. Mr. Malero, do you need to speak to Mr. May?
Yeah, real quick, Judge, I guess.
Okay, and then Mr. Smith, we'll get to your case next.
Thank you.
Good morning, sir. You're Mr. Henry?
Yes, Your Honor.
Okay, Mr. Malero, your attorney's working with another client right now. And then we've got one other, and we'll get to your case as soon as we can.
Okay, thank you.
this is file 25-22194-FH and 25-22196-FH. People versus Matthew Ryan May. We are here today for pretrial conferences in both of those cases. First, may I have the attorneys place their appearances on the record.
Phoebe McClure, on behalf of the people.
Salvatore Malero on behalf of Matthew May.
And Mr. Malero, where do we stand with Mr. May's cases today?
Yeah, I'm requesting an adjournment on this. I thought we were going to have a Mr. May in the recovery court here in Lenawee County, but he lives in Jackson, so we're trying to arrange for that to happen over there. So that's the purpose of the request. If I can make that happen, I would bring him in as soon as possible to get that done. That's the basis for my request.
All right, Ms. McClure.
The only thing I'll indicate is, again, the prosecutor's office does object to him entering recovery court, but that'd be about it.
All right, I'll set this for September 3rd at 8:15 a.m. And at that point, if there's no resolution, it will be set for trial.
Thank you, Judge. We'll know in about 2 weeks, one way or the other.
Okay, Mr. May, you can let the officer with you know that you're done with court for today.
All right, thank you.
And Judge, what was the next pretrial date? I apologize.
September 3rd. And Mr. Malero, do you need to speak to Mr. Smith?
I don't think so, Judge.
Okay. This is file 25-22247-FH People versus Dustin Wayne Smith. We are here for a pretrial conference in this case, and we're proceeding today by video conference. First, can you have the attorneys place their appearances on the record?
Phoebe McClure, on behalf of the people.
Salvatore Malero on behalf of Dustin Smith.
And Mr. Malero, where are we with Mr. Smith's case today?
Judge, I believe we're waiting on the transcript from the preliminary exam. There was a revised plea offer that I need to go speak to Mr. Smith about as well. So I'd ask to adjourn this for another pretrial.
Okay, Ms. McClure, anything to address from the people's side?
No, Your Honor, we would agree.
Okay. Does look based on the order date that the due date on the preliminary exam is August 13th. So let's set the trial for August 27th. And make sure that we have the preliminary exam and know where we're going at that time. Mr. Malero, would you do a stipulation in order for that adjournment, please?
I will, Your Honor. And Dustin, I'll be over to talk to you probably. It won't be this week, but I'll be trying to get over there soon. Okay.
Yes, sir.
All right. So, Mr. Smith, you are all set for today. You can let the officer with you know that you're done for.
Thank you, Your Honor.
And Mr. Malero, do you need to speak to Mr. Henry?
Yeah, real brief, Judge. I'll be quick.
So Mr. Henning, there should be something on your screen asking you to join a breakout session. Just go ahead and click join.
It's not on there yet, Judge, Your Honor.
Okay, let me try this 1 second.
I see it now.
Okay. Sure, I'm able to get a new date for.
I was, thank you, Judge.
This is file 25-22326-FH, People versus Kareem Jamal Muhammad Henry. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Morning, Your Honor. PB McClure on behalf of the people.
Salvatore Malero on behalf of Kareem Henry.
Mr. Malero, does Mr. Henry wish to have the information read?
Your Honor, at this time, we would acknowledge receipt of the information, waive its reading in open court, waive any defects of the time and place of service. We would plead not guilty to counts 1, 2, and 3, and the habitual offender fourth notice. Further, we would acknowledge receipt of a witness list and ask the matter be set for pretrial.
Okay, I'll enter not guilty plea for Mr. Henry. Will set a pretrial for August 27th at 8:15 a.m.
All right, thank you, Judge.
Okay, Mr. Henry, you can let the officer with you know that you're done with court for today.
Okay, thank you, Your Honor.
Thank you, Judge.
Thank you, Mr. Malero. Believe we're all
Okay.
set.
Good luck.